A barrister engaged to represent a client in court will usually be briefed by a firm of solicitors. The client deals with the solicitors who prepare the case for the barrister. However, this usual process is not always followed. Barristers are allowed to take what are called direct briefs, where they deal directly with the client and without the assistance of a solicitor. This is generally considered quite unwise. In this particular case, a young and inexperienced barrister, perhaps struggling to find sufficient work, took on a direct brief, and it was very unwise. Laghaifar, the client, had been the subject of a default judgment against him for unpaid debts. A default judgment occurs when a party does not respond to a claim, and so the other party wins by default. Laghaifar had tried to have the default judgment set aside but had failed. 2 years later, so well outside the usual 28 days, he decided to appeal against that judgment. This is when the young barrister, Wren, became involved. Mr. Wren drafted what the court considered to be very poor submissions, advancing 2 arguments which were both unsuccessful. The other side argued that the submissions were so hopeless that they were unarguable and represented a failure by the barrister to satisfy his duty to the court. Duty to the court includes a duty not to advance a hopeless case which represents an abuse of court. As a result, they argued that the barrister himself should pay the costs of the winning side in the appeal. Justice of Appeal Davies did not hold back in his opinion about the barrister. However, he said, "It is one thing to present a case which is barely arguable, but arguable nevertheless, but most likely to fail. It is quite another to present a case which is plainly unarguable and ought to be so to the lawyer who presents it. In my opinion, with respect, it is improper for counsel to present, even on instructions, a case which he or she regards as bound to fail, because if he or she so regards it, he or she must also regard it as unarguable." The court found that even though the case argued by the barrister was poor, it was not so poor that it constituted an abusive process. Even clients who have very poor prospects are entitled to bring their case to court.